Again, this is the first annual conference, so still working out a couple of things, it looks like. I know Cal, when he talked to me about this, he talked about how beautiful and sunny it was going to be. I haven't quite seen that yet. Hopefully it's coming, but it doesn't sound like it. But I think the content and the information is still going to be fantastic. So are you ready? We're going to go ahead and get started here with Mr. John Daly. Mr. John Black, I'm sorry. Mr. John Black.
All right, how's everybody doing? No, you got the wrong guy. I'm John Black. I'm a trial lawyer. I've been doing this 20 years. I started in a big firm doing plaintiff's work for big companies, and then I got sick of billing by the hour. So now I primarily sue insurance companies. Daly and Black is in Houston, although I fished most of my life right out here. And we've got offices in Houston and Denver. And I love what I do because insurance companies cheat, they delay, they deny. I mean, they've got a license really to do what they want. And Mr. Hodge is exactly right that the industry, right, what we do is under attack. Insurance companies have all the leverage, they've got the money, they've got the lobby. They write the rules, they write the contracts. And so working together is really essential. I want to start by thanking Cal and his team and Sean Hodge as well for putting this together, because I do a lot of these events. This really is a great lineup of talent. There are great lawyers here on the plaintiff and defense side. I think I even saw David Salyer, great defense lawyer here, mediator. So you got a wealth of information here concentrated over the next couple of days. So what am I going to talk about? I'm going to talk about examinations under oath, okay? EUOs, right? Anybody not heard of an EUO? We all know what they are. And I call it weapons of mass destruction because examinations under oath have become weaponized, okay? They have become weapons of the insurance industry that are used offensively instead of to investigate claims. Right? So what do I mean by that? Let me see if I know how to work this. Yes. So I looked last night for a definition, a standard definition of examinations under oath, right? Can one person agree on what an EUO is? I generally came up with this definition, right? It's some formal proceeding, right, where an insured is under oath, right, usually in the presence of a court reporter, so that the oath is administered, questioned by an insurance company representative, right? And almost every single insurance policy that I've seen, right, in almost every state has some right that the insurance company has to conduct an examination under oath. And why shouldn't they, right? The idea is, hey, I'm the insurance company, we have questions, we may want to investigate, we may want additional information. It seems very innocuous. It seems very innocent. So why worry about an EUO? If you represent a policyholder that is going to be subjected to an EUO, why should you care? I mean, it's in the policy, they have a right to it. Why be nervous? I'll tell you a story. I have a client right now that has a fire claim, and he hadn't hired a lawyer. Not until just recently. For weeks, the insurance company had been asking for bank records, phone bills, evidence of him paying his rent on time, evidence that he lived at the address. It literally looked like formal discovery to me. It was the craziest shit I'd ever seen. And they wanted an examination under oath. And he calls me and says, hey, should I just go down there and answer whatever questions they have? I've given over all of this stuff. How many of you think he should just go down there and, without any advice from a PA or a lawyer, and just answer the innocent questions that they have? Hell no. But why? I mean, it's in the policy, right? I mean, the typical EUO provision reads pretty simply. It's under the conditions section. Conditions, blah, 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 and then at the bottom, as often as we reasonably require, what the hell does that mean? Okay? You're going to submit to an examination under oath and sign and swear to it. Great. All right, so where are the rules? Where does it say who gets to ask the questions, or how long, or what information they can use? Or are there things off limits? What's the scope of the examination? I mean, if it says as often as they reasonably require, can they ask for 2 or 3 or 4 or 5 of these? And what happens if you say no? Should a policyholder simply say, yeah, we'll do whatever you want and show up wherever you want under any conditions? What if they show up with lights, bright ones, like these, and a videographer, and they show up with not an insurance examiner, but a lawyer or an engineer to cross-examine your client? What do you do? And if you do something, what do you point to as your evidence or your source of complaining? All right, here's the punchline. It's the Wild West, all right? That's the state of law in most states regarding what rights you have when your client is being subjected to an examination under oath. People say, well, it's a lot like a deposition. Everybody know what a deposition is, right? Lawyer sits down, puts you under oath, asks you a bunch of questions, has a bunch of documents. So it should be no big deal, just like a deposition, right? Yeah, until it's not, right? There are no rules regarding objections. Right? Like I said, no rules on length, scope, dispute resolution. What if you get in there and you disagree? You're the PA, and you're sitting there with your client, you're like, I think that question's off limits. Insurance examiner says, no, I don't. How does that get resolved? Have you committed a breach of contract by instructing your client not to answer? There's no arbiter, there's no decision maker appointed in the policy to decide who is right or wrong in that context. It's just the insurance company that can point back to the policy and say, you breached. You didn't do what we asked you to do, because we get to ask for an EUO as often as we reasonably require. There's no discovery. There's no rule regarding where it should occur. I mean, the bottom line is it's really nothing like a deposition, okay? Except that your client, the policyholder, is under oath, unprepared, usually, and subject to a complete ambush. In a deposition, I have the right to ask the other side for documents before the deposition. My client gets a chance to read them as they're being examined. I get to decide where it's going to occur. If it's harassing, I can stop it. So why should this be any different? So it's a creature of contract, is what the insurance company would say. It's a right that we negotiated for, that we have in our policy, and therefore we can do what we want. And if you don't agree, it's a breach. Okay, but there are limits. My goal here is to teach you some of those limits and what to do to police a deposition or an EUO, right? First of all, who asks the questions? The short answer is, in most policies, because it's totally left blank, the insurance company can designate whoever they want. They can designate an engineer. They can designate a desk adjuster. What I have seen more frequently is they designate lawyers. Raise your hand if you've seen that happen. Why on earth would they designate a lawyer to come in and, quote unquote, investigate a claim and examine your client under oath? Anybody? Right, to set them up, right? Cal, just before I started speaking, was asking what I was going to talk about, and credit to Sean Hodge, who gave me the idea, said, look, if they're asking for an EUO, it's because they know something, because they're trying to set you up. Now, the cynic in me believes that, because I've done this for years. They would say, no, that's not true. We're just investigating the claim. So when they use a lawyer, there are a couple of reasons, right, why they may do that. And look, the answer to this question is they can designate anybody, okay? You're in a very tough position to come in and say, oh, I'm sorry, this man or woman cannot ask the questions, because you're really barren when it comes to arguing that point. But let me give you a little something to think about the next time a lawyer shows up for a deposition, or an EUO, right? If the attorney is acting as an investigator, what he or she does is not privileged. See, insurance companies and their defense lawyers like to, and not David Salyer, where are you? I love you. But a lot of them like to play cute. They say, well, because a lawyer is handling the file and asking questions, what he or she does is privileged, you see. And what information we give them, you see, that's privileged because they have a law degree. And so I'm very sorry, but if we get into litigation, you can't ask questions of that lawyer. Okay, well, that is bullshit, as they say in Texas. It's not true. And I'm going to tell you why. There are really two forms of privilege, okay, in the universe of lawyer privilege. There's attorney-client privilege. That's usually pretty easy to spot. Lawyers talking to a client. Well, that's not the case in an EUO, right? You got some insurance person asking questions of some insured, not attorney-client. Okay. In the capacity that the examiner is sitting, right, they're an investigator. They're not acting as a lawyer. They're acting as someone that, on behalf of an insurance company, is investigating a claim. Now, I mention that because it's very important. If the insurance company takes the position that they're doing anything other than investigating the claim at that point, if they've already made a decision, then why do they have a lawyer examining your client? Let that sink in. If they have already made a decision and they already expect a lawsuit, why are they examining your client? All right, so back to the other forms of privilege. The other is work product, right? A lawyer does work. I think that my work relates to a lawsuit that I have or that I am anticipating. Therefore, it's privileged, right? So, in Texas, like most states, if you anticipate a lawsuit, you expect a lawsuit is coming, then a lawyer's work can be work product and therefore not discoverable. But here, because the EUO has to be used as a tool of investigation, it can never be work product. It can never be privileged. Right? An EUO is always supposed to be an investigative tool. The examiner is always acting as someone that is investigating. Therefore, they can never be working truly as a lawyer that is creating work product that is privileged. Bottom line, what does all of that legal stuff you just said mean? It means you get their file. If this goes further, if you can't resolve it after the EO, you can damn well demand every document that that examiner had, communications that they have, exchanges between that lawyer and their lawyers inside the firm, and with the insurance company. And when you ask for it, what do you think they're going to say? They're going to say all of the bullshit that I just told you is wrong, okay? And so when they do, remember these slides and what I said about what work product means and what attorney-client privilege means. And also realize that once they've taken that position, they may have trapped themselves. How have they trapped themselves? Well, if they're taking the position, okay, and this is nuanced but really important, if after an examination under oath, they take the position that all of the stuff you asked for is somehow work product, ask them to explain how. Because the minute they say in writing, or otherwise, I guess, that it's work product privilege because they anticipated a lawsuit, then it's no longer the investigative tool that they claimed it to be. And what they're doing is bad faith. What they're doing is trying to set your policyholder up. They're going in and using a contractual tool to show and support a denial they already know they're going to issue and not investigate the claim. It is not work product. Does that make sense? So why do they want the EUO, right? I mean, if an insurance industry person were here, I'm sure they'd say, look, we just want to investigate. We want to get admissions from the insured. We want to know what they have to say about the property damage. They're the most knowledgeable person to ask about the damage to their property. And we want to know things about, like the date of loss or the extent of damage and the scope. And those are all very reasonable things to ask about. Damn, you're right. That sounds so reasonable. Now, imagine an EUO provision in your medical insurance policy. I just went to the cardiologist, okay, because I'm kind of a hypochondriac. And I sat there for like 6 hours. They did all these tests, right? Can you imagine if they said, now, Mr. Black, before we cover these, we'd like to sit you down and we have an examination under oath. Oh, yeah, okay. Why? Well, because you're the most knowledgeable to talk about your health condition and your heart. And we just have a couple of questions. Oh, yeah, okay. And they sit me down with a lawyer, and they start asking me questions about my mitral valve, okay, or my carotid artery, or my blood pressure readings over the last 12 years, or other shit I just don't know. And I'm like, I don't know. And what if the examiner is a really smart lawyer with a medical background? Then I'm like, oh, this guy's really smart. And he knows way more stuff than I do. And I'm kind of nervous and like, your client, unfortunately for the client, is not always the best expert, is not always the most informed person on the extent of damage, the scope of damage, even the date of loss. How many of you have had clients that are like, shit, I don't know when the hail fell. I mean, I think it fell this month. Right? I mean, how many of your clients are like, yeah, that drip edge needs to be replaced? Right? Said no client ever. Okay? And so when you're examining a client in an EUO, why on earth are they not entitled to some form of representation or advocacy by an expert? I mean, look, the policy doesn't say that they're not, does it? Does the policy say that they can't bring in their own expert? Does the policy that I just showed you say that they can't bring in their own lawyer or adjuster? It doesn't. And so because these EUOs, not always, but increasingly are used as setups, you got to be careful. And the more money at stake and the more complex the claim, the more you got to be careful. Because what really should be an investigative tool only is almost always used for other purposes. To have admissions later in trial. To lock in your client who may not know anything. Well, Mr. Black, I see you've been representing Sally Jones here on this claim, and I know you say there's a lot of damage to her property, but she didn't know a damn thing about it in her EUO. Well, that's because she's not in the construction business. And guess what? Ms. Johnson's never been on her own roof or her attic, okay? And she couldn't spot a hail hit if her life depended on it, okay? And none of that is surprising, but it gets thrown in my face. So how do you protect your policyholder if you know that the EUO can and might be used as a setup? And by the way, this is just some case law for those of you nerds like me that want some legal support, right, for the idea that when lawyers examine witnesses and EUOs, what they're doing cannot be used as work product. I've cited a case, Jackson v. Downey, okay? All right, shifting gears a little bit. Because the EUO right is contractual, because it's in the policy, it can be waived. Any contractual right in the world, really, can be waived, okay? The law says you can get rid of it, right? If it's your right, you can relinquish it. There are two ways to waive it. One is expressly. You can say, I don't want an EUO. That's an express waiver. The other is to sit around and never ask for it, right? Or to do things inconsistent with it. That's a form of waiver, right? Implicit waiver, right? Through conduct. And so what I advise other lawyers and adjusters is there are timetables in which to investigate claims. Y'all know, right? In almost every state, certainly this one, okay? And there is a time period during which an investigation is ongoing, and then it comes to an end. And so if an insurance company spends all of its time investigating and requesting documents or whatever, and it gets to the end and it has never asked for an EUO, and it makes a coverage decision and writes a letter and says, we think we only owe you this, okay? Then a lawyer shows up, or a PA, and they're like, oh, we need an EUO. Do you think they're entitled to it? Here's my point. I believe once an insurance company has made a decision, has taken a position as to coverage, has put it in writing, has all of the information they claim they've needed, they're stuck. They don't get a chance to go back and ask for a right that they've now waived. Okay? The policy doesn't say they have it forever, and the law says that they have a certain amount of time to investigate the claim. I'm not going to get into timetables and all of that. But you guys know from your own experience that once that's done, it's done. And it's not an endless bite at endless apples for them. And so what I tell people to do is look for conduct by the insurance company that implicitly, right, waives the right to the EUO. What could it be? It could be things like them not agreeing to the scope, right? Them not agreeing that the examiner is an agent of the insurance company. And I'm going to get to why these stipulations are important. Them not agreeing that the examination isn't privileged, okay? And that the claim has yet to be denied. I tell my lawyers, and I'll tell adjusters, that when you show up with a client at an examination under oath, before your client says anything, get the examiner to stipulate on the record to certain basic facts. Hi, you're asking the questions. I'd like you to agree to a couple of things. Mark it as an exhibit, hand it to him and say, I want to make sure that you're an agent of the insurance company, that you're agreeing the examination isn't privileged, or any of the documents you have, right, or your file. Make them agree that the rules of civil procedure do not apply, and they'll gladly do that, okay? Make them agree that communications with counsel, right, that they've had inside their firm or externally are also not privileged, and that the examination's taken in a manner that's not intimidating. Proper venue, no bright lights, right? If they don't agree to those things, I think you can argue, look, you're waiving your right to this contractual provision. You're insisting on things that are not part of the deal, okay? That is a form of waiver on their part. When they try to impose things on the process that don't exist, okay? And so I get those agreements up front on the record. And let me tell you, the minute they agree And they agree to most of these sometimes. The one they love is that the exam will not be taken in accordance with the rules of civil procedure. Now, what do I mean? When you, as a lawyer, take a deposition, it's pursuant to the rules. Some of you have heard that if you've been in depositions. The rules are the rules of civil procedure that govern objections, length of time, all of that stuff. Insurance companies aren't bound by it. And they love that they're not bound by it until they find out that you get to play Wild West cowboy or cowgirl too. And then they hate it. Okay? Because they like the Wild West, but they don't like when you show up with your own gun and horse, and you're like, I can play Wild West too. Okay? I don't think the slide is... Can we go to the next slide? Okay. Separate point. An EUO can be time barred. Okay? Waiver is one argument. Hey, you lost the right to do this. You waived it. Another is you're out of time. Okay? And so I've cited a couple of concrete insurance code provisions in Texas, right? From sections 542, 056, and 057 that lay out the time period to investigate claims. If EUOs are asked for outside of these parameters, you can take the position validly that the EUO is time barred. It's waived, and you're not entitled to it as a matter of right or law anymore. And we have argued this to courts, right? Where timetables have passed, they never asked for it, they're like, we've investigated the claim, and they're like, we need an EUO, pre-suit, right? And we're like, hey, look, you don't have the right anymore. See these right here? This is Texas statute. So if you don't comply with these deadlines and you don't conduct the EUO within it, you've lost your right to it, right? That's my position. Insurance company would say that's not true. Policy is silent as to when we can take it. It doesn't say that we can't take it at the end. You're wrong, Mr. Black. And I'm like, that's cute, okay? That's a great argument, the policy, but this is actually Texas law. And so if the EUO is a tool to investigate, which it is, and is a condition, which it is, then you damn well better do it within the time period. Because what it's not is a deposition, right? If it were a deposition, you can take whenever, but that's not what this is. And so remind them, when they forget, that if they're outside the time period, it's time barred. All right, next slide. That's a long way of saying check deadlines, right? So what do you do to protect, right, the insured? This is, right, this is kind of the punchline. Look, when you're operating in the Wild West are not firm rules, but these are things that we do, that my firm does. And before I get into it, I'll say that I'll bet every lawyer that does policyholder work that's in this room today would help a policyholder or PA with an EUO, without taking a piggish fee. We want to make sure that claims are handled properly. And having a lawyer show up to an EUO, and certainly a PA, I think is the safest course always. I do not like my clients, once they've made contact with me, ever going to an EUO alone. I don't like it. Too much can go wrong. Once they've hired me or they've talked to a PA, go to the EUO and be engaged in the process. And so there's nothing in the policy that prohibits it. I've had lawyers scream at me. I've had insurance adjusters say, you can't do this. I had one do it to us a week ago. There was one, no kidding, where They wanted to videotape, and they had lights and the whole thing, and we're like, we're showing up via Zoom. And they're like, well, you can't do that. Well, why the hell not? They're like, well, we have a videotape here and lights and a whole setup. And I'm like, okay. Well, we're showing up by Zoom. So we've complied with the policy. We're here, we're under oath, ready to answer questions. Well, this is improper. Okay. Why? Right? You get it. Right? So show up, get engaged, and prepare your policyholder like it's a deposition. I mean, because it is. So what I do is I go through the file as I know it. I sit down, I interview my client, I ask some questions, I figure out where the soft spots are. I figure out if I'm them, what am I going to ask? How am I going to set you up? And then I tell my client, they're going to try to screw you this way. Okay? This is what this is about. That is me representing my client effectively, right? In the face of something that clearly can and will be used against them, right? I don't permit crazy intimidation, BS tactics. The lights, the video cameras, it's going to be at a lawyer's office, all of that stuff. Like, you want an EUO, we're going to do it by Zoom, or it's going to be in my office, and we can have a court reporter, and that's it. Okay? I police the scope vigorously. Okay? What do I mean by that? I know what reasonable is, right? And most of you do too. I'll bet, good lawyers in here like, Philip Sanhover. I mean, all the great lawyers here will tell you, they have been in these settings where, their clients are asked stuff that has nothing to do with the claim in an EUO, nothing. I mean, that stuff I'm like, hey man, don't answer that. Right? We're not here to, right? Police the scope. And if they get upset with you, right, and they say that's improper, just tell them, look, I'm doing my job. That's improper. If you disagree about scope, we can take it up with the court if there is a filing later. That's it. Keep your objections, the vitriol, the bickering on the record to a bare minimum. Just say that's improper. It's beyond the scope. That's it. Your obligation as a policyholder is to show up and to provide reasonable cooperation, right? Really. Policy doesn't even say that, but and to answer questions under oath. It is not a limitless fishing tool for the insurance companies, despite what they think, right? I ask in advance for copies of whatever is going to be used to be sent to me. And if stuff is used that I haven't seen, I don't let them ask questions about it. It's that simple. If it's in the investigative file and you're going to ask my client questions about it, like, I should be able to see it. If it's part of the formal investigation, like, ask for that a week or so before the examination and insist on it. Just say, look, we're not, we just want the file just like you have it. This is not an ambush. Make sure you get your stipulations. And if any of you later want me to write them out for you, I'll write them out for you. Okay? Maybe not today, but I'll send you an email and tell you what mine are. But get your stipulations on the record before it starts, including the one that says the rules of civil procedure do not apply. And then that gives you a license, really, to object. And even, wait for it, answer questions for them. Let's say you're the public adjuster. Let's say you've worked the claim. Let's say you know the damage better. Let's say you've been on the roof or in the attic or whatever, and you know the answer better than your client. Now, the policy requires the answer to be from the client under oath. I get it. But it doesn't say you can't help your client. And I'd rather be out in the open about it. Have my clients say, look, I don't know the answer to that, but I defer to, my public adjuster over here, Mr. Freed, right? He can answer the questions. He knows better. Then he can answer it. That's it. And so I have seen that done, and I don't believe it's improper. Now, I've seen them scream and yell about it, But the reality is your client often will not know the answer to certain questions. That's okay. It should not be used as a setup for your client. Your client should be perfectly safe saying, I don't know, and I defer to this person here that's the expert on construction issues that I brought. That's it. So in certain circumstances where they've asked for an EUO, just file a lawsuit. Okay? Let me go to the next slide. If the heat is too much, what do you do? I mean, maybe it's a file that you just got. Maybe it's a file that's got a lot of complexity. Maybe the EUO, you're very nervous, okay, about documents you may not have. You really feel like the client's going to get set up. You just don't know, okay? And you don't want to breach your duties to your own client or put them behind the 8 ball. File a lawsuit. Have a lawyer file a lawsuit, okay? Now, insurance company screams, oh my God, they filed a lawsuit. We were just investigating. We weren't even done. Okay. Well, we need an EUO and you refused. You breached the contract. Okay. So in Texas, okay, all right, and this is heavily dependent on what the policy actually says. But in Texas, it is almost always the case that if you violate that condition of providing an EUO, the remedy that the insurance company has is abatement of the lawsuit. That means the lawsuit's put on hold. It doesn't mean that the lawsuit goes away. What it means is now your client has a lawyer. The EUO process is slowed down. The lawyer frequently can get discovery. And what happens 95 times out of 100 is the lawyer goes to the court and says, hey, instead of an EUO, we're just going to do a deposition. Okay? Then it really does turn into a formal discovery instrument where you get and have the right to get documents beforehand, where they cannot ambush you, where you have counsel engaged. And so in those situations, and I've got one right now, we filed a suit, and the insurance company screamed and yelled, and same thing, you violated our rights. And okay, I'll tell you what, we'll abate the suit. We'll just do this as a deposition. I need the claim file. I need this, that, the other. The records you're going to use, and they're like, that is not a fight they'll win with most judges. They know they have to turn it over. They know that it will then be a deposition. They usually cooperate, and it becomes an exam like any other lawsuit exam, okay, for examination. So I'm not saying that's always a solution. I'm saying that's a nuclear option, right, where you feel very uncomfortable with what's going on. My default rule is whether you're in litigation or not, make sure someone knowledgeable is there with your client, right? The caveat, the warning, policies are changing. Surprise, not better for us, not better for policyholders, right? Worse. And you see more and more before you sue or that kind of language. And so before you do this, right, make sure you've talked to a lawyer. And before the lawyer files, make sure he's looked at the policy or she to ensure that it's not just a condition that is going to put you in an abatement situation or not something else, all right? That's just a big red flag. All right, next slide. That's it. I want to leave a little bit of time for questions. I think I got 7 minutes, 8 minutes or so for Q&A. Anyone? Yes, sir. Yeah, so the short answer is yes, right? A investigation of a claim should not be privileged, okay? And if it is, then they have already made a decision that they're going to file a lawsuit. It's only work product if they're anticipating sued. Does that make sense? And so if they're taking the position that it's truly work product, and therefore they know a lawsuit is coming, they're waiting for it, whatever, then I believe they're acting in bad faith. The investigation period should not be one where they are cloaking things in privilege, ever. It can be as simple as saying facts, F-A-C-T-S, facts are never privileged, number one. Two, the investigation of a claim is not privileged. Those are facts that the policyholder is entitled to. Three, work product privilege, which is the only one that would even theoretically apply, applies only when you expect a lawsuit and are anticipating a suit. And dear sir, if you're anticipating a suit, please let me know on what date you started anticipating it. Yeah. 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 They'll accuse you of practicing law the way they'd accuse a contractor of adjusting. I mean, I get that concern. I mean, it's helpful for the lawyer later that takes the file over to see something in writing where the insurance company at least identifies what portions of the file they claim are privileged, so we can fight about it later. Yes, sir. I think that's one way. You can say, have you concluded your investigation? If they said, yeah, then you don't need an EUO. If you have anything from them that says or suggests that they've concluded their investigation, then why the hell are they investigating with an EUO? I mean, they can't just say, well, because we have a right to it. It doesn't work like that. It is a right to investigate a claim, right? I mean, I think that's a good point. Mr. Sanoff. Yes. Yeah. I mean, look, guys, the EUO and the policy is an investigative tool. It's not an absolute right. I mean, if you look under, can we go back to my second slide? Sorry to be a pain in the ass. You had it just a second there, right? So under the duties after loss, right there. So all of the things that are listed usually in the EUO section, right, are things that you do to help the insurance company investigate, right? Provide access to damaged property, provide us with pertinent records and documents, and subject to an examination under oath is one of those things that you give them a right to. It's a right of access to information, right? All of these are rights of access points, right? And so once they've concluded their investigation, then their rights of access aren't needed anymore, right? And if they say, we do. We've decided that we do. No, you've already made a determination, right? This is not an unfettered right. Now look, I'm not saying it's going to win in court all the time, okay? But I think I'm right. And I know when I'm wrong. You talk to my girlfriend, maybe not. But a lot of times I do. And so I think that I'm right here that, these rights have to have some reasonable restriction, some reasonable limitation to them, right? To be absurd, right? I like taking arguments to the absurd. Do they have a right to a EUO? Let's say you filed a lawsuit. Let's say you're 17 years into litigation. I'm actually trying a case in Beaumont in 2 weeks that is 17 years old. Let's say you're 17 years into a lawsuit, and the insurance company comes up and they're like, and they've already denied the claim. They denied it in 2004. I'm not making this shit up. And they're like, Mr. Black, we want an EUO. Huh? Excuse me? Right? Everybody would look at them like they're insane. Why? Well, because you made a decision in 2004. And what do you need now? Well, we got some additional questions. No. That's not what it's for. Oh. That's what I think. Y'all been great. If you have more questions, one more. You tell me. Pertinent records, I don't know. It's not defined, right? Those aren't capitalized terms. They're not proper nouns in the policy. They're just little p, little r, pertinent records. So they'll argue pertinent records is whatever they want. Okay? Well, that's not what it means. Let's say you think pertinent records are the records that are reasonably related to the claim. That sounds pretty reasonable. Who decides if you guys disagree? A judge. But there is no judge, right? Because you're just in the investigative process. And so what I would say is, let's say I'm a public adjuster and they're like, hey, we want this guy's birth certificate and we want his high school SAT exam. And we want, right, and a bunch of stuff. You're like, yeah, that's stupid. So I would say, sir, here is a copy of the pertinent records, quote the policy, send it to them and say if there are records that you think that are missing, identify them and tell me why you think they're pertinent. That's it. Because you'll never, I'd say never, all right, you'll rarely agree with an insurance company on what pertinent records means. That's the Tom Brady 2-minute warning. Since I don't have his skills, I'm going to go to Beaumont and get ready for trial. But look, there are a lot of great lawyers here. There are a lot of really good public adjusters here. This is a wealth of talent over the next couple of days. If you guys have questions, we don't send bills for our time. I think one of my partners is coming the last day to speak. Call us, email us. We'll answer whatever question you have and help wherever we can. Thanks. Y'all been great. Appreciate it.